Good morning. My name is Tanner Ledownian. I'm the civil rights advocate and litigator that Miss Connors was just.
I'm sorry. Could you state your address, please, sir?
Yes, it's 152 Wayne Place Southeast, Washington, D.C., 20032. So let me just start by saying I'm not here to get anybody into trouble. That's not what this is about. I want to inform you guys of a situation that we really do need to get addressed, and honestly, we're going to. So I'm preparing to litigate this on behalf of the more than 700,000 people that are currently imprisoned here in America illegally and unconstitutionally because the states have failed to follow the very basic procedures and processes enumerated and codified in the Constitution of the United States for the adjudication of a crime. Guys, no state can create its own alternative legislation, substitute that for the guarantees of the Constitution, and go out and enforce that. That is unconstitutional. The state of Alabama has done just that. Every single time the state goes out and performs an arrest without having an indictment by a grand jury, as required by Clause 1 Amendment 5, a crime is committed. So I have approximately 17,000 criminal affidavits from victims that have been charged by way of information as opposed to indictment from right here within the state of Alabama. These affidavits, they identify two different crimes in particular. The first is Title 18 U.S.C. subsection 242, which is deprivation of rights under color of law. What that statute states is that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution commits that crime. The second crime is Title 18 U.S.C. subsection 241, which is conspiracy to deprive of rights. What that statute says is that when two or more persons conspire with the purpose of depriving any person of any rights secured by the Constitution commits that crime. Now, the laws of criminal conspiracy with regard to public officials, all of you, what that states is that any person who, having knowledge of any of the wrongs conspired to be done and who have the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined as defendants in the action. So upon having been provided with this notice today, letting you know that you guys are paying the sheriff's department to go out and execute unconstitutional warrants that derive from a direct breach of a constitutional obligation, I ask you guys, please, let's work together to fix this problem. Because the alternative is that I'll have to convert these criminal affidavits into criminal complaints. I don't want to do that. Please don't make me have to do that. But we got to work together here. You guys are going to have to step forward in truth, understanding the limitations of power that the state of Alabama has codified in the Constitution of the United States and the exercise of your power. But if you continue to pay these public officials to abridge their constitutional codified obligations, criminal sanctions can come from that. And I don't want to go down that path. Please don't make me have to. So I know that as soon as we're done, you're going to go to your attorney and you're going to ask that attorney whether or not what I'm saying is true. That attorney is going to point you to a case from 1884 from the United States Supreme Court called Hurtado versus California. And before you guys choose to rely upon that as the foundation, I must remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution, because that must be done by an authentic and explicit act of the people in accordance with the special amending procedure of Article 5. Furthermore, judges cannot legislate. We know that because Clause 1, Article 1 says all legislative power is vested in the Congress of the United States. So please don't rely upon the foolish belief that the judge-made ruling is superior to the Constitution of the United States of America. So the difference between today and tomorrow is negligence to willful criminal conduct, because upon having been provided with this notice, letting you know that you guys are paying people to abridge their constitutional obligation, the matter becomes much more serious after this. So the notice is on the record. I would ask you guys to please review that notice. Everything is in it. My contact information is there. I would love to work with you guys to fix this problem, but we're going to have to work together. So I want to end it with this, right? Because I want to entice you guys to go in the right direction, because I know that this is a difficult decision that you guys are going to have to make here. As soon as we're done, you're going to have to decide whether you're going to follow a judge-made ruling, the lowest form of law, or the Constitution of the United States of America, the object of which your fidelity is bound. I'm going to pray that you guys make the right decision. The United States Circuit Court has identified a two-part test to determine abuse of discretion, okay? The second part of that test says that any erroneous view of the law is an automatic abuse of discretion. An erroneous view of the law would be that in your legal contemplation that the lowest form of law, judge-made ruling, is superior to the Constitution of the United States of America. That would be an obvious erroneous view of law. Therefore, if you continue to pay these public officials after being made aware, an automatic abuse of discretion will have occurred in accordance with the United States Circuit Court. Thank you guys so much. God bless. Have a great rest of your day.
Can I
Mr.
have,
Downey, I'm trying to get the kernel of the complaint. Is it that in Alabama, people are arrested before they're indicted? Is that the,
In the state of Alabama, you permit your prosecuting attorneys under your inferior state constitution, you permit your prosecuting attorneys to charge by information or indictment by their discretion. It's written in your constitution. And I've already served your attorney general, so he's well aware of this. I've already served your Supreme Court justices. They're well aware of it. We're now serving the legislative branch. That's all of you. But yes, there's two issues with that. The first issue is that you can never use discretion with regard to one's lawful obligations. Obligations must be performed, otherwise you're abusing your discretion to break the law. That's issue number one. Issue number two is that you can never create a law that permits the prosecuting attorney to decide who has a constitutional right and who does not. That's a violation of the Equal Protection Clause of the 14th Amendment. Yes, the state of Alabama has got tens of thousands of people currently imprisoned that did not receive an indictment by grand jury, despite the fact that that is required by Clause 1 of Amendment 5 to the United States Constitution. I'm not saying these are good people.
so it's the information that is the problem, that you're saying that it should only be an indictment and that the additional availability of information as a prosecutorial tool that's what's unconstitutional.
There are three ways to charge a person with a crime. One is the presentment to a grand jury. One is an indictment from a grand jury. The third is an information. And information goes to a judge, and the judge determines whether or not there's sufficient probable cause to assume that a crime has been committed. What happens there is it eliminates the neutral, unbiased third-party decision maker. The grand jury is there for that role and that purpose. We need to make sure that we have someone in place that is not associated with the state as an agent of the state that's in the process to make sure that the state and the prosecutor is not exceeding the power authority statutorily conferred upon them. Thank you so much.
Got it.
God bless you guys. Thank you.
All right.
What are you suggesting that the county commission do pertaining, are you suggesting that we defund the sheriff's office? I'm confused on exactly what it is you're asking from the commission. We don't pay judges. I mean, I understand that we're responsible budgetarily for the sheriff's office. So what are you suggesting?
That's a great question. Thank you for asking. You guys fund the sheriff's department, and you guys fund the resources for the courtroom, county courtroom, as well as also the jail. If the sheriff is going out and executing a warrant, and I'm not saying that they know that they're doing this, but if they're executing a warrant that is based upon an information, not an indictment, that sheriff is now complicit in a criminal act, a conspiracy to deprive rights. Whether they know it or not is irrelevant. Negligence of the law is no justification for having broken it. So when they arrest that person, they put them into a county jail, whom you guys fund, that housing or that holding is unconstitutional because the Constitution says no person shall be held to answer for capital or otherwise infamous crime unless on presentment or indictment of a grand jury. I'm not an abolitionist, right? And I can't tell you guys how to exercise your power. All that I can do is I can say that if you guys pay people to abridge their Constitution, that is an emolument violation and it is a crime. And we're hoping that we can work together to fix this problem. You guys, as the legislative body, provide oversight. The oversight that you can provide is you can direct them to act in a constitutional manner in the course of their business. Because if they don't act in a constitutional manner consistent with their business, upon having been provided with this notice, you can become complicit yourself within it. I don't want to defund the sheriff's department, but I do want the sheriff's department to act in a lawful constitutional manner and protect the individual rights of the people in the exercise of their power.
Okay.
Thank you.
Thank you.
Thank you so much.
Mm-hmm.